Danny Savalos, an NBC News legal analyst. And Danny, let's talk about this new second-degree murder charge against the primary officer, Derek Chauvin. Normally, second-degree murder essentially means an intentional killing. But here, prosecutors are pursuing a different legal theory called felony murder. Can you explain it and explain why it may mean a conviction is easier to obtain here?
A felony murder is a killing that is unintentional, but it results from a felony committed in the course of that felony. And traditionally, it was inherently dangerous felonies like burglary, arson, robbery, kidnapping. But Minnesota expands that definition by statute and allows a broad swath of felonies. And included within that is assault in the third degree. So in this case, all the state needs to prove now is that Officer Chauvin intended to commit third-degree assault. That's inflicting bodily harm and substantial harm results. Certainly substantial harm resulted. And then they have that predicate felony, and as long as they can prove causation, then they have felony murder, which is admittedly an unintentional killing, just as the third-degree depraved mind murder is in this case.
So in other words, if they prove a third-degree assault and that third-degree assault caused the death, they have a conviction.
Yes, and my thinking is that makes it easier to charge the other officers because all they have to prove for aiding and abetting is that the other officers helped Chauvin commit that third-degree assault. And if they can show that, then they can latch on to the felony murder that Chauvin allegedly committed. So I think that makes an easier path for prosecutors to bring the charges against the other officers as well. Because otherwise, charging them with aiding and abetting third-degree murder, that's just aiding and abetting a highly reckless act. And it's hard to say that these officers intended to bring about what was an unintended consequence.
Real quickly, many cases in the criminal justice system end with guilty pleas, and often prosecutors will try to get others charged in the case to flip, to testify against the primary defendant. Is that something you expect could happen here?
It's always possible, and prosecutors generally like to get people to cooperate and offer them maybe lesser charges. But often in the case when officers are charged with murder, they have a lot of motivation to roll the dice. They know that historically juries tend to look at officers a little different. These are people that are lawfully permitted to lay their hands on other people in a way that citizens are not. And officers can raise all their training and experience that shows that something can escalate from resisting arrest to something deadly. And what you find is that officers often get the benefit of the doubt. And that's why they probably often decide to elect to go to trial rather than plead guilty to some felony that lands them in prison for about half a decade.
All right. Danny Savalos, our legal analyst, thank you very much.